Alright, hello and welcome to my video blog. This video blog comes out of a conference talk that I gave to a group of provincial court judges in Alberta, and I talked about some of the developments in the Supreme Court regarding the critical admissibility test of probative value and prejudice after the Queen and Hart. And I want to talk about that today as a video blog topic to sort of explain where I think Hart may have changed our way of looking at admissibility through their reconstruction, or I guess they would say alteration or development of the probative value concept in Hart. So let's dig right into it. So a pretty helpful place to start, especially those who are new. To be honest, if you're really new to this topic, I advise you go look at my capsule on probative value. But here's a brief summary. When you're measuring probative value, which is the key part of the admissibility calculus in evidence, you're generally looking at two things. How strongly does the evidence tendered, or as I put it, evidence tendered being represented by A, how strongly does it lead to proposition B, the inference that you need to prove at trial? And the second part of this calculus concerns how important B is to the trial. So there will be in any trial lots of things you need to prove. Some of them are more critical than others. So the more centrally located this proposition is in the trial, the more probative value the evidence has. Now, what's interesting about probative value is that while it's a core aspect of the admissibility calculus, at its core is this idea of how strongly the evidence leads to the inference is really determined by logic, experience, general knowledge, and common sense, which, as you might imagine, in some cases are pretty clear, but in others are a little more complex. At the end of the day, probative value requires a determination as whether the existence of fact A makes the existence of fact B more probable. But again, what actually makes it more probable is actually determined by things that are not usually absolutely provable. We're talking about logic. Okay, that's provable to some extent. But experience, general knowledge, and common sense is a little bit more vague. Now, what's interesting about probative value is that while it's a very obviously important part of evidentiary admissibility, and it's been around for centuries, we've been using this calculus of probative value and prejudice to determine whether a piece of evidence is admissible, what's kind of amazing is that there is still an open question that hasn't been fully resolved by the jurisprudence, and it's this one here. Because I just said to you that this A to B calculus is based on a very vague arrow, and what that actually means, and unfortunately what that means is logic and human experience. And the question of to what extent a party can challenge logic and human experience is a really important question for the admissibility of evidence. To make a long story short, if the party cannot challenge it, and we accept for admissibility purposes that human experience and logic are what they are, and they cannot be challenged, then at the end of the day, the admissibility, it becomes harder to challenge the admissibility. That's what this is all about. However, if you can challenge the logic or human experience, you can have a lot more questions resolved at the admissibility stage, rather than simply saying that weaknesses in the inference that you're trying to draw based on logic or experience go to questions of weight. So let's just say that this question is a big question, because it really talks about how much evidence we're willing to exclude where we cannot show, or where it can be disputed, whether that evidence proves what you want it to prove. Now, I'm going to show you how I think the Queen and Hart factors into this discussion, because many people know about Hart. Hart is about what are called Mr. Big investigations, and Mr. Big investigations were a Canadian police technique where they would pose as a criminal organization to a suspected person, and what they would do is they would create this criminal organization and try and draw the suspect in, ultimately asking the suspect to confess something or other that they were obviously investigating him for, in order to get in good with the group. And it was a very effective technique in terms of getting confessions. So what happened was there were suspect aspects to this investigative technique, and there were concerns that it was producing wrongful confessions. So the Supreme Court examined this, and what they did was they said Mr. Big investigations are problematic. So they said, yes, they're problematic. So what they did was they said, well, how do we deal with these problematic investigations? Well, on its face, it simply says, well, this is a new special common law rule of evidence, which creates a presumption that Mr. Big investigations that produce confessions, those confessions are inadmissible unless the Crown can prove that they should be admitted. But if you look closely at Hart, what you can see is that the new rule, aside from the presumption, which is definitely different, the new rule is nothing more than a balance of probative value versus prejudicial effect. So the question that I want to explore is whether the logic of Hart, which ultimately questions whether something is probative, can be applied to other pieces of evidence. Well, to answer that question, it's helpful to look at how confessions were treated, because Hart was about confessions. And I can tell you that generally speaking, leaving aside policy reasons like here where we excluded confessions that we were worried weren't voluntary or were taken by police authorities, and leaving aside the charter entirely, confessions were almost always admitted. And the reason for that is because of the common sense idea that a person who confesses to a crime is more likely to have done it. A versus B, it's obviously a very material point in the trial, but more importantly, you don't confess to something generally unless you're likely to have done it. So the probative value of this was always regarded as high, because the common sense would be, why would people confess if they didn't actually do it? And not surprisingly, weaknesses regarding the confession, like the accused's suggestion that he didn't mean to confess, those just went to the weight of the evidence. They did not affect probative value. That's how confessions were dealt with. Now, how does Hart deal with this? Well, I think Hart addresses the problem in Mr. Big by what I call supercharging the probative value assessment, by asking courts to look more carefully at these inferences that get us from point A to point B, and where there are significant weaknesses in these chains of reasoning, that evidence might not have enough probative value to be admitted. Let me show you how that goes. I mean, look at these quotes. I suggested to you that when a person confesses, they're more likely to have done the offense to which they confess. But Hart says that we need to look at those inferences more closely, saying it would be artificial and self-defeating to ignore defects in the evidence. And most importantly, here's the point. A confession provides powerful evidence of guilt, but only if it's true. A confession of questionable reliability carries less probative force. In essence, they ask us to look at those links in the chain, and where a party can show that there are demonstrated weaknesses and there was plenty of evidence. It's not always going to be easy to get that evidence, but there was evidence in Hart to show that you couldn't rely necessarily on these confessions. Probative value drops dramatically. That's the important part of Hart. So what's the impact of Hart? Well, I think that Hart says you can challenge common sense notions that are part of the inference package where there is evidence that shows that the common sense idea or human experience should not be adopted, especially where you have strong indicia of unreliability. Now, maybe this is a little bit abstract. When would you do this? Well, one of the most contested parts of evidence law right now is ID evidence. Let's say you have a witness and they see somebody and they then go and identify them at a lineup where there's 4 different people there. And they identify this person in a lineup and say, well, that is the person that I saw. Traditionally, weaknesses in this lineup, or weaknesses in the way the person was identified, went to weight. But we now know a lot about the way lineups are conducted, and there are some types of lineups that essentially produce unreliable identifications. It's really no different than Hart. Why can't we assess these using probative value? And I think after Hart, we can. Now, before you get excited about every piece of evidence being contested on the nature of probative value, I don't think this is going to happen in most cases. What's important to remember is that the probative value prejudice is really a scale more than anything else. It's a scale in which you're balancing things. So at the end of the day, the important part is that in Hart, the Mr. Big confessions involved a certain degree of illegality because the accused, to admit this evidence, he had to show that the accused was joining a criminal gang. That is the type of evidence that has prejudicial effect. So by lowering the probative value calculus, you were able to essentially lead to admissibility because there was some prejudicial effect. Remember that to exclude evidence, you still need to change the overall calculus, which means if there's no prejudice to your evidence, you're not actually going to do anything simply by lowering the probative value, because ultimately this scale of admissibility is still going to favor admission, because that's the way these scales normally work. So it's important to remember you've got to hit both ends of the equation in order for this to make any real difference. But I think it's still possible. Certainly, if you can weaken the ID evidence in some cases, maybe you can weaken it to 0, that the probative value is just nil because the evidence is too unreliable. And in other cases, perhaps you can show different types of prejudice. So that's a little bit of a primer on the Queen versus Hart, and it's one reason so many evidence scholars are excited about this case. It will be very interesting to see whether in future courts look at the probative value assessment with a little bit more rigor, especially where there's evidence they are concerned about with relation to whether or not it actually proves what it's tendered to prove in the first place. I hope that was of some interest to you. So anyway, have a great day.